we have anyone ready to deputy petition?
No, Your Honor, not yet.
Size or expecting any contested hearings for?
Judge, I believe the bond hearing on Mr. Shannon, but nothing contested in terms of an MTA or MTR.
Deputy McLeish is J. Warren Penny in the courtroom.
Your Honor, he is not yet, but we can certainly get him in here.
He's one that we can take care of, I think, relatively quickly. His brain hearing via Zoom.
Can you get Mr. Penny, please? Right now.
No, actually, it's not really a few on this case. The deal they're offering. That's done to that as well. That's right. Do you want person will try to make this?
And Your Honor, while we're waiting, do we think Mr. White will be here in person or does he Zoom? Because we can get his client up here if he's going to be Zooming.
Not sure. Check this.
Mr. Penny? Yes, ma'am. Come on up here, please.
Yes, ma'am. How you doing, Your Honor?
Doing fine, sir. How are you?
Doing great.
All right, we're gonna bring Mr. Patton in. He's connecting right now. All right, good afternoon, Mr. Patton.
Afternoon, Your Honor.
All right, this is cause number CR 22390, State versus J. Warren Penny. Show that defendant requested an evidentiary hearing in court today as said the defendant's motion to suppress for hearing. Any announcements, Mr. Patton?
Yes, Your Honor. Your Honor, yesterday I received a plea offer from the state when I called to explain, and I apologize to the court of the conflict I had today. And it's the bare minimum plea based off the current charges without enhancements. I just need to relay that to my client because after I filed this motion for the motion to suppress, Mr. Penny received 3 new charges out of Wood County that I'm trying to work out a global plea, but I got an offer yesterday, and if with court's permission, if I could just visit with him, I think we could set a plea date. I just haven't talked to him about actually withdrawing the motion, and forgive me, Your Honor, I just couldn't make it to Canton yesterday to speak to him because he's still there in the jail.
So you're not going to argue the motion today, but you're not going to withdraw it either?
Well, Your Honor, I believe I will if I could just talk to him about the plea offer. I don't want to set myself up if he gets upset for me for withdrawing the motion that he asked for me to file without discussing the state's offer with him and implications with the 3 new charges out of Wood County.
I think the issue though is that the state was ready to have their officer appear today and the court was ready to go forward on the motion to suppress. It's my understanding that you were withdrawing the motion to suppress. And then I think the state relied on that in canceling their witness.
Okay, I apologize, Your Honor. I spoke to him yesterday and told him I was not moving forward, and it was my impression he got with the witness and told him that he wasn't needed today. And I'm sorry, Your Honor.
And I don't want to speak for Mr. Woodwalk. I'm just telling you the impression that I got through my coordinator. So I think probably what I'm going to do now, Mr. Patton, is since you're not ready on the motion, I'll just deny the motion to suppress. And you can refile it and urge it at a later time. And you can make a finding of good cause as to why we do it later rather than today. But I'll just deny the defendant's motion to suppress on the basis that it's not being argued today.
All right. Thank you, Your Honor. And I apologize to the court.
Okay. All right. Court will set Mr. Penny then for a docket call. We'll look for an announcement on whether or not we're going to trial, solving the case. Mr. Patton, are you available on either June 1st or June 15th?
Can I say something? Stop.
No, that's not.
Your Honor, I'm available either one of those days. June 1st is good.
Okay. All right. Court will set Mr. Penny then for docket call on June 1st. That'll be at 1:30.
Thank you, Your Honor.
You're welcome, sir.
We'll address it.
How are you? Can you tell me who you are?
I'm Aaron McLeish, I'm a deputy here.
Be the sheriff or a jail deputy?
Sheriff's deputy.
That's good.
We having a problem, Deputy McLeish?
Having discussions.
Will you let me speak to him
Let's
before?
go.
Then I-
Let's go.
Look, Mr. Patton.
All right. Thank you, Your Honor.
Have a good day.
How you too?
All right, Mr. Stanford, come on up. All right, this is in the matter of pretrial release conditions for Jacob Stanford. Court has received information from the pretrial police department indicating they have concerns about Mr. Stanford. They've indicated to me that he's admitted to the use of Delta 8 on April 5th, 2023, that he's delinquent in supervision fees, drug testing fees, court-appointed attorney fees. He's never submitted a payment. So they're asking the court to address his non-compliance. Go ahead, Mr. Ashman.
Okay, thank you, Judge. Thanks for giving us opportunity. One, the fees and the financials have been caught up. Mr. Stanford's taken an opportunity to remedy that today. And he apologizes to the court for the delay in that. Two, the Delta product that he used is commercially available and is not at the time, as I understand it, classified as a controlled substance by the state of Texas. And I had a long talk with Mr. Stanford about how toe on the line, once you get into the Delta 9s and the heavier THC byproducts that are made in Oklahoma, sold at gas stations here that we think are legal, they are not legal in the state of Texas. And so our request to the court is for some grace. One, because we don't think that that falls onto a violation because it's not at this time classified as a controlled substance Delta 8. Anything else probably in that gray area. The other thing, and Mr. Stanford can speak to this, is that as a young man up until the early teenage years, he was a cancer survivor, fought cancer off, and has been informed recently that he has a new tumor in his ear canal, in his left ear canal. And so the use of Delta 8 is purposeful for pain and anxiety treatment, not for getting high, getting by, not to avoid or get away with non-compliance with the court's pretrial release orders. So our request is allow continue on release and to keep moving forward.
Why did it take me setting up for a hearing before he paid a single dollar? That's how he was ordered to do. Why did it take them? I don't want to hear from you. I want to hear from your judge.
We don't have any good excuse for that, Judge. Just don't.
It doesn't bode well for your client that if he were to be extended a probation offer, doesn't bode well if the court would accept it because he can't comply with conditions of pretrial release. There's no way in the world he's going to be able to comply with probation. So this is already a mark in his file when if there's a probation offer brought to me, probably not going to accept it because this is indicative of his ability to willingness to comply. Because I can't have people on probation and bring them to court every month to make sure they do what they're supposed to do.
Yes, Judge. And I've explained that to him, that these pretrial release conditions are like tryouts for a probation offer, and that fouling this up will jeopardize that. And I think he understands the gravity, what you just said, and I'll admonish him for sure continue compliance.
State, do we have any timeline on whether Mr. Stanford's case is being presented to a grand jury or being filed by the state?
Judge, state has still not received a case from the arresting agency. There was some turnover in the department over there. I have been told that they are still working on getting that packed up to us. My understanding is that everything is essentially done. It just hasn't been packaged up and brought over to us for prosecution. It's my understanding that their intention is to do that. But as of today, we don't have a case in our office yet.
Thank you, Ms. Heisel. All right, Mr. Stanford, I'm going to leave you on bail. I'm going to leave you on pretrial release. but there's gonna be no more Delta 8, there's gonna be no more THC. If you need medication, you need to go to the doctor and you need to get a valid prescription. Yes, sir. And you better be on time with your payments. If you can't make your payments on time, then I'm just gonna take you off bail, put you back in jail. Sir, clear? Sir. All right. There's no further setting with the court up until the time that you get indicted or the case gets rejected. So you need to just continue reporting your pretrial release officer. Sir. All right, your excuse. Thank you, sir.
Wait, oh, you're taking.
Mr. Nichols. This is cause number CR 2187, State versus Jason Eric Nichols for docket call.
Judge, one, my apologies for my confusion. We reported Veterans Court earlier this month, and we are tentatively back in Veterans Court. Jason and I were both admonished about continuing to perform what was going to be expected of him. We're meeting those conditions. Jason was given a Veterans Court diversion program notebook, and I was emailed last week by that court's coordinator to provide the court with an order reinstating Jason. I haven't done that yet because I was traveling the last 4 or 5 days. I have shared that electronic mail correspondence with Ms. Heisel. She doesn't have any opposition to us continuing to work that Veterans Court process, and my fault for not being here today and making sure Jason was here today at 9 a.m. sharp. I did call, I'm very grateful for the court for reaching out to us. I immediately called Mr. Nichols. He was at the VA this morning getting aftercare, and I didn't want him to miss that. And I asked the court's permission to let us show up at 1:30 for a reset. Our next Veteran Court docket is actually next Friday. And right now, we'll do whatever the court needs us to do. I believe Jason will be reinstated based on the coordinator's email, but I don't have that order yet. And part of that delay is because that email came through while I was in trial and then immediately left for Oklahoma the next morning. So we just haven't had a chance to address it. So if we need to come back in a month to further check in with Your Honor as to what's going on with Judge Roach's court, we'll absolutely do that. And again, my apologies for today's error.
Remind me where we're at on this case.
Jason has pled into Veterans Court as a pretrial diversion program. His condition here is to do whatever the Veterans Court requires. And the first 2 steps of Veterans Court for Mr. Nichols was 60 days in the Kaufman County Jail. And then the inpatient rehabilitation, which I believe is not quite, very close to 120 total days in Bonham, Texas. He was released in the last 30 days, drug tested here, drug tested at Veterans Court, and we reported back to Veterans Court to deal with the issue of the order putting him out of Veterans Court, which came in while he was still in Bonham. So we've straightened that out. And as I understand it, we're under an obligation to report back to that court next Friday.
So is Mr. Nichols in the Veterans Court or is he not in the Veterans Program?
I don't have an order putting him back in, but I was emailed and asked to provide the court with an order doing that. I can show Your Honor that email too. That came on April 23rd. So, but our understanding when we left Veterans Court is we're in, because he was handed a notebook, admonished to the judge to get his act together. And, that's kind of how Veterans Court goes, right? There was some disapproval about conduct at VA Bonham. He admitted and took responsibility for whatever that misunderstanding was. And the court is, as I understanding, allowing Jason to continue on in the Veterans Court program.
State, do you want to be heard on this?
Judge, I will leave it up to the discretion of the court, whether you just want to remove him from the docket, let him continue on his pretrial intervention as planned, or whether you want to set it for a month out to get that status, to get the confirmation. I do have the email from the Veterans Court Coordinator asking for the motion to reinstate so that they can put him back in. So I am personally satisfied, but if the court wants further documentation, I certainly understand that. This is essentially a non-reporting PTI for our purposes, with the sole condition being that he successfully complete the program over there. If they're going to continue him in the program, then we're going to continue him on pretrial intervention.
So you're comfortable with the size?
Yes, Your Honor.
All right, then let's let Mr. Nichols get back on the pretrial intervention contract that he's on now. And I'm not going to set him for compliance. I just going to expect that if he does not get back in the program, either you or the state will alert me so we can set him.
Yeah, I'll absolutely do that, Judge. We'll have a firm answer for that, I believe, next Friday at Veterans.
All right, thank you, Mr. Archie.
Thank you, Judge.
Free to go.
Let me excuse for the jail docket. Judge.
Yes, thank you, sir. Sorry, I appreciate it. Mr. Schmidt, are you ready?
I am, Judge.
Are you ready?
Matthew Hogg.
All right, this is cause number CR 21-125, State versus Matthew Tom Hogg. Motion to revoke. Go ahead, Mr. Schmidt.
Met with the state yesterday, hoping to resolve this case. We're not going to be able to. I'd ask for that May 30th contested date. In addition, Mr. Hogg has informed me that due to a pending civil lawsuit against the county and the court in which he's filed. No, it's not pending. It's happening. It's happening. Yes. So he believes there's a conflict of interest or a grounds for recusal of the court. I told Mr. Hogg that I'm going to meet with him Monday morning, and he can explain to me the ins and outs of that. And if there's any merit to it, we'd file a motion. But other than that, we'd proceed on the motion to revoke May 30th.
All right, court sets Mr. Hogg for contested hearing on Tuesday, May 30th at 1:30.
Do you know what hearing?
And that'll be a final hearing for Mr. Hogg.
Yes, sir. Yeah.
You ready on now, Mr. Schmidt?
Dugan Lee Toms.
Mr. Palms, CR 22-158. What do we have today, Mr. Schmidt?
Mr. Toms has said on the state's motion to revoke, we negotiated with the state and come to an agreement in which the state has agreed to withdraw their MTR and continue Mr. Toms on community supervision with placement at Safe P as a condition, as well as absorbing any new costs associated with the motion to revoke.
Do you have that? Do you have the state's motion there with you?
I do, Judge.
In probation, you've reviewed this agreement, probation's in agreement with Mr. Palms and safety.
Yes, sir.
All right, thank you, Ms. Burns. All right, Mr. Thomas, raise your right hand. I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can vote again. All right, Mr. Toms, I've heard what Mr. Schmidt had to say about the state withdrawing its motion. You staying on probation and doing safety as a condition. Tell me why I should approve that.
Well, I am trying to better myself, and I feel it maybe this would be necessary to to help me figure out what's wrong with me, because apparently there is. And so, I think safety will help me and so I can get on with my life and be right.
Have you ever been to rehab before?
No, sir.
If I send you down there, you're gonna go down there and you're gonna try to the best of your ability to learn what it is that they have to teach you. You're not gonna go down there just to waste your time and my time. Try to avoid prison. Is that right?
Yes, sir.
All right, Mr. Toms, has anybody threatened you, forced you, pressured you to make you feel like you had to amend your conditions of community supervision to include safety?
No, sir.
All right, court will grant the state's motion to withdraw. The state's motion to adjudicate, the court will amend the conditions of Mr. Toms to include the substance abuse felony punishment facility as a condition of community supervision, in addition to the new financial obligations as a result of the state's motion. The court grants that motion.
Thank you.
Who's next?
Misty Reeves.
Misty Reeves, CR 23-69. Good, Mr. Chief.
Judge, so we're prepared to enter a plea this afternoon.
Yeah, what are those terms?
The state's recommending upon a plea of guilt that court defer a finding of guilt, place Ms. Reeves on 5 years community supervision, assess $12,241.81 in restitution, joint and several with Orion Augenstein. In addition to that, 0 fine, court costs, and $520 reimbursement fees.
You said $290 court costs, and you said how much on reimbursement? $540?
$520.
$520. Any 1245s of any other cases?
No, sir. I believe this is the only case pending.
Okay. All right, Ms. Reeves, ma'am, if you'll raise your right hand, I'll place you on both. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lower your hand. Your name is Misty Reeves, is that correct?
Yes.
And Ms. Reeves, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
Since I've been in here, they diagnosed me with bipolar.
Okay. Are you currently on any medication or under a doctor's care for bipolar?
For in here I am.
Do you feel like you have a rational understanding of what's going on today and that diagnosis is in no way affecting your ability to understand what's going on?
I know what's going on.
All right. And you're represented by your attorney, Mr. Schmidt. Are you pleased with him as your attorney?
Yes, sir.
You feel like you've had enough time to talk with him about your case and that you've had all your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
Mr. Schmidt, do you believe Ms. Reeves to be competent?
I do.
You've explained to her her rights as they pertain to this plea agreement?
Yes, sir.
And do you believe that she's entering into this plea intentionally, knowingly, and voluntarily?
Yes, sir.
All right, Ms. Reeves, you are charged by indictment with a third-degree felony offense of theft of property greater than or equal to $30,000, less than $150,000. That does carry a range of punishment if you were to be convicted and sentenced to no less than 2 years in prison or more than 10 years in prison, and a fine not to exceed $10,000. I see, as Mr. Schmidt has indicated to the court, that the state's recommending that upon you pleading guilty, that the court not find you guilty today, but place you on deferred community supervision for a period of 5 years, order you to pay that restitution, your court costs, and your reimbursement fees. I want you to know that if the court approves this plea agreement and places you on community supervision, if during that 5-year period you violate any of the terms of your probation, the state can file a motion, bring you back to court. Court would conduct a hearing. If the court finds that you violated your community supervision, court could do a number of things, including adjudicating your guilt. That means convicting you of the offense, revoking your community supervision, and assessing your punishment anywhere within that range from the lesser of 2 all the way to the maximum of 10. Do you understand that?
Yes, sir.
Understanding all that, do you still wish to go forward with your plea?
Yes, sir, I do.
All right, Ms. Reeves, how do you plead to theft of property greater than or equal to 30,000, less than 150,000?
I'll plead guilty.
You pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Schmidt, any objection to states one?
No objection.
States one is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
Nothing further.
All right, Ms. Heisel, can you give me the facts to support the plea?
Judge, if you'll give me just 1 second, I'll jump in there for you. Sorry, Judge, this is Mr. Woodwick's case. I'm grabbing them really quickly. All right, Judge, looks like the date of offense is December 1st of 2022. The victim reports his RV stolen in Garland. Precinct 4 constables go out to the defendant's residence and notices an RV on a separate issue, notices an RV that has a broken window, punched ignition, and a radio being removed. He runs it. The defendant gives a story how they bought it on a payment plan. But essentially everything about the vehicle has been altered in such a way that indicates that it is stolen. There is extensive damage to the vehicle. So the victim is seeking $12,241 in restitution, it looks like.
All right, thank you, Ms. Heisel. Any objections or additions, Mr. Schmidt?
No, Judge.
All right, then based on the evidence presented to the court finds that there is sufficient evidence to convict Ms. Reeves of this offense. Court will follow the plea agreement reached between the state and the defense. The court hereby defers the finding of guilt. Ms. Reeves places her on 5 years community supervision, orders her to pay restitution in the amount, correct me if I'm wrong, Mr. Schmidt, $12,241.81.
That's correct. Joint and several.
Court will order that restitution be paid joint and several with Ryan Augustine. Court also orders her to pay court costs of $290 and reimbursement fees of $520. Ms. Reeves, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I have you step over with the deputy to be fingerprinted, and the probation officers will give you more information. Who's next?
Bob Land.
This is CR 18145, State versus Bobby Wayne Land. Motion to revoke.
That's correct, Judge. We're prepared to enter a plea on the state's motion.
All right, go ahead and give me those terms.
On a plea of truth, the state's recommending that Mr. Land's community supervision be revoked, that he be sentenced to 5 years TDCJ, assess the balance of his financial obligations, which appear to be $2,014 in fines, $95.45 in court costs, and $915 in restitution. He has also 487 days credit time towards that sentence.
All right, just 1 moment. I'll look at this. All right, Mr. Land, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help me God?
Yes, sir.
All right, thank you for agreeing. All right, Mr. Land, you appeared before the court on May 8th, 2018, and you pled guilty and were convicted of the offense of assault of a family or household member by impeding breath or circulation, 3rd-degree felony. Court heard the evidence, followed the plea agreement in your case. Court assessed your sentence at 10 years confinement in TDC, but the court suspended the sentence that day, placed you on community supervision for 10 years, and ordered you to pay a $2,500 fine. On February 21st of this year, the state filed its motion to revoke your community supervision. As you can see here, they have alleged 5 separate counts of ways that you have violated your community supervision. Do you feel like you've had enough time to discuss this motion with your attorney, Mr. Schmidt?
Yes.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
Mr. Schmidt, does your client waive the formal reading of the motion?
We do waive, Judge.
Does he intend to plead true to all 5 counts?
Yes.
All right. Then, Mr. Land, I would ask you at this time, how do you plead to counts 1 through 5 as alleged in the state's motion to revoke?
True.
Are you pleading true to each one of these counts because each count is in fact true?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead true today?
No, sir.
All right, Mr. Schmidt, you do believe Mr. Land to be competent to enter into this agreement?
I do.
All right, then based on the evidence presented in the motion, and Mr. Schmidt, let me ask if you object to the admission of defendant's waiver of rights and clear truth.
No objection.
That's submitted and court takes judicial notice of the defendant's judicial position. Based on the evidence presented to the court finds that Mr. Bobby Wayne Land has violated the terms and conditions of his community supervision. The court will follow the plea agreement reached between the state and the defense. The court hereby revokes the community supervision of Bobby Wayne Land. Assesses the sentence at 5 years confinement in the Texas Department of Criminal Justice. Orders him to pay the balance of his remaining financial obligations. And the court awards him 487 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Land, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. Please step over with the deputy to be here.
Thank you.
And
Who's next, Mr. Schmidt?
Rosamond Shannon.
Rosamond Shannon, CR 2363. I believe this is a motion to set bond. Is that correct?
It is, Judge, or a motion for reduction in bond on the state's motion to adjudicate.
And Mr. Shannon, are you gonna call Mr. Shannon as witness tonight?
I will, Judge. Also briefly, we need to go ahead and set Mr. Shannon for a contested motion to revoke on that May 30th. And then I'd ask to proceed with our motion to reduce bond.
All right, the court hereby sets Rosamond Shannon for contested hearing on May 30th at 1:30. Mr. Shannon, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So be good.
Yes, sir.
All right, well, you can just speak it loudly, clearly, and speak one at a time so the microphone recorder can take down what you have to say. Go ahead, Mr. Shannon.
Thank you. Mr. Shannon, you are the named defendant in the state's motion to adjudicate this cause, correct?
Yes, sir.
And we've had an opportunity to go through the state's motion together, is that correct?
Yes, sir.
Now, currently, you're being held on a $50,000 bond on that motion. And we have filed a motion to reduce that bond and ask the court to consider that as all.
Yes, sir.
Now, ultimately, as we went through the state's motion, you believe, and it's your contention that you have meritorious defenses to those, to the counts of violations against you, correct?
Yes, sir.
If you were able to make bond on this case, you understand that we're set for a final contested hearing on May 3rd.
Yes, sir.
Are you asking the court to reduce your bond so that you can visit me in my office and spend more time preparing for that motion?
Yes, sir.
Where do you live, Ms. Shannon?
309. So.
Sulphur Springs?
I'm sorry, Mr. Schmidt. I don't know. It's probably an audio technical issue. I didn't, Ms. Grisham and I couldn't hear what he had to say.
Yes, sir. State that address again, please.
Apartment 309, Hemland, Sulphur Springs, Texas.
Himland, Sulphur Springs, Texas. And do you have transportation, Mr. Rosen?
Yes, sir.
Mr. Shannon?
Yes, sir.
And so you would have the ability to get here to court on May 30th for your final hearing.
Yes, sir.
But ultimately, we do need to spend time together preparing for that. And you're in the hopes that you can bond out so that we can do that in my office.
Yes, sir.
And ultimately, your bond is set at $50,000. Is there an amount that you could pay a bondsman at this point to bond it out on that case?
20,000.
You think your family or your friends or whatever can come up with $20,000 to pay a bond? Not 20,000 cash, but to pay a $20,000 bond.
Yes, paid. Yes, sir.
Okay. Is there any reason why this court should believe that you, if bonded out, will not show up for your hearing?
No, sir.
And did you have any problems in the past getting back towards court?
Once.
Okay, but you addressed that and
Yes, sir.
dealt.
Yes, sir.
Okay, I'll pass the witness.
State, any questions?
Yes, just briefly, Your Honor, if I could have just a second. Mr. Shannon, I'm not asking if it's correct information. I'm just asking, is it not the case that the state is alleging that one of the violations of your community supervision was that you failed to report to the community supervision office?
And Judge, I would object this. That's a legal question based on the information contained in the state's motion. However, count one does so allege.
All right, court will sustain the objection.
And Mr. Shannon, do you have any continued contact with the victim in this, in the underlying cause?
Yes, sir.
Your Honor, I'd pass the witness.
Mr. Smith,
No further questions.
all right, anything further from the state or anything further from the defense?
Your
No.
Honor, state would just ask that the bond remain where it is based on the charge and based on the allegations in the state's motion. If the court does see fit to lower the bond, we would just ask for no contact conditions with the victim in the underlying case.
Thank you, Ms. Heisel. Mr. Schmidt.
Judge, I think under the circumstances, Mr. Roseman was on deferred. Ultimately, we will come back on the 30th in the hopes of convincing to reinstate his probation. Ultimately, I'm not certain the status of whatever conditions were imposed upon him after his plea on this case the first time. However, we would have no objection to any conditions that the court would impose and ask that the court grant his motion to reduce to 20,000 so that we could adequately prepare for his defense in the state's motion on May 30th.
All right, thank you, Mr. Schmidt. All right, the court will take the evidence and arguments under advisement and issue a ruling at the conclusion of today. In the meantime, the court has set Mr. Shannon for hearing on May 30th. That will be at 1:30. Mr. Shannon, hang on. Your hearing will be at 1:30 unless you make bail. If you make bail, then your hearing will be at 9 a.m. in the courthouse, okay? 9 a.m. if you're on bail, 1:30 if you're in jail, okay?
Thank you. I believe that's all I have on your docket, Judge.
Yes, I think so. Thank you, Mr. Schmidt.
Well, thank you.
Who are you ready on?
Judge, we can start on Miss Williams.
All right, Kayla Williams, CR 21-314. All right, Ms. Williams, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. All right, Mr. Manning, it appears that there's an agreement in this case with regards to the state's motion to adjudicate appears that she would be pleading true to all 7 counts alleged. The state is recommending that she be convicted today of evading arrest or detention with a vehicle, and that her punishment be assessed at 3 years confinement in TDC, with her receiving 78 days credit towards that sentence for time that she spent in jail, and that she be ordered to pay the remainder of her financial obligations. Is that correct?
Judge, I believe that count one is going to be abandoned. My understanding is that Dallas County abandoned or rejected or dismissed that case. And so I spoke to the state, and I believe that's our agreement.
That is our agreement to abandon count one, Your Honor.
Is that reflected in the paperwork?
I've interlineated on the motion to adjudicate the state's exhibit. I've crossed count one out.
What about on the second page of the judgment, where the court makes findings about specific conditions of community supervision, which says A, B, B, D?
It still lists condition A as violation.
So is count one, A violation A rather?
Yes, Judge.
Okay, so state, you're gonna need to change the judgment. If that's
Judge, we will send the court a corrected judgment that excludes that count.
All right, Ms. Williams, do you feel like you've had enough time to speak with Mr. Manning about this motion, and that you've had all your legal questions answered, and that you understand everything that's going on in this case, everything that you've read and signed?
Yes, sir.
You're pleased with Mr. Manning as your attorney?
Yes, sir.
Mr. Manning, do you believe that Ms. Williams is competent today, and that she's entering into this plea intentionally voluntarily?
I do, Judge.
All right, Ms. Williams, you appeared before the court on January 6th, 2022. You pled guilty to the third-degree offense, evading arrest or detention with a vehicle. Court heard the evidence that day. Court found that there was sufficient evidence to convict you. The court followed the plea agreement that you reached with the state. Court placed you on, court did not convict you that day, deferred a finding of guilt, placed you on 3 years community supervision, ordered you to pay a $4,500 fine plus court costs and other fines and fees. Court then finds that in October of 2022, the state filed its motion to adjudicate and alleged 7 separate counts of ways that you have violated the terms and conditions of your community supervision. Mr. Manning, does your client waive the formal reading of the state's motion to adjudicate?
We do, Judge.
Court finds that the parties have agreed to abandon count one of the state's motion to adjudicate. Therefore, Ms. Williams, I'm going to ask you at this time, how do you plead to counts 2, 3, 4, 5, 6, and 7 as alleged? Are those counts true or not true?
True.
Are you telling me that those counts are true because in fact they are true?
Yes.
Yeah, you're not telling me that they're true just so you can get a 3-year prison sentence.
No, true.
Okay. All right. And has anyone threatened, forced, or pressured you to plead true to any of these counts?
No, sir.
Court will accept the defendant's plea of truth. Mr. Manning, any objection to the admission of the defendant's waiver of rights of plea of truth?
No objection to state's one.
All right, that's admitted, and the court takes judicial notice of Ms. Williams' judicial confession. Anything further from the state,
No, Your Honor, we would rest and close at this time.
from the defense?
Nothing from defense, Judge.
All right, Ms. Williams, based on the evidence and your pleas of true, the court finds that you have violated the terms and conditions of your community supervision. Court will follow the plea agreement you've reached today. Court hereby adjudicates your guilt, convicts you of evading arrest or detention with a vehicle, a third-degree felony. Court finds counts 2 through 7 to be true. The court hereby revokes your community supervision, assesses your punishment at 3 years confinement in the Texas Department of Criminal Justice, orders you to pay the balance of your financial obligations, and the court awards you 78 days credit towards your sentence for the time that you have spent in jail on this cause. Ms. Williams, you hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. Please step over with the deputy to be.
And Judge, I just emailed Ms. Tabraham and Mr. Manning a corrected, I believe it's page 7, the way that it works out, which would remove that count.
Thank you, sir. Anyone else, Mr. Rainey?
Yes, Judge, ready on Ms. Simpson, Jerica Simpson from this morning.
All right, Ms. Simpson. This is cause number CR 2225, State of Texas versus Jerica Dion Simpson. Ms. Simpson, if you'll raise your right hand, I'm going to place you in front of. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
All right, you can lower your hand. All right, Ms. Simpson, you're here on the state's motion to adjudicate your guilt. Have you had enough time to talk with your attorney, Mr. Manning, about this motion? You understand everything that's going on in your case, everything that you've read and signed today? Are you pleased with Mr. Manning as your attorney? I can't hear you.
Yes.
Okay, just speak up for me. Mr. Manning, do you believe that Ms. Simpson's competent today?
I do, Judge.
Do you believe that she's entering into this agreement intentionally, knowingly, and voluntarily?
I do.
All right. Does she waive the formal reading of the state's motion to adjudicate?
She does.
And is she pleading true to all counts?
Sorry, Judge, hold on 1 second. Yes, Judge.
All right, Ms. Simpson, you appeared before the court previously on December 17th, 2020. You pled guilty to the second-degree felony offense of aggravated assault with a deadly weapon. The court heard the evidence, found that there was enough evidence to convict you. The court followed the plea agreement that you reached with the state on that day. The court deferred a finding of guilt, did not convict you, but placed you on 5 years of community supervision, ordered you to pay a $4,000 fine. It was on August 3rd, 2022 that the state filed an amended motion to adjudicate and revoke your community supervision. And in that amended motion, they have alleged 6 separate counts of ways that you have violated your community supervision. Ms. Simpson, how do you plead to counts 1, 2, 3, 4, 5, and 6? Are those counts true or not true?
Six.
Yes. Yes.
True or not true?
True.
Say it loud enough.
And so you're telling me that all counts are true, is that correct?
Yes.
Okay.
And Judge, if I may, I explained to Ms. Simpson that she has been reset multiple months, multiple settings, in an attempt to get caught up on some of these conditions. And she's actually made headway on some of those conditions, completing, I think, as much as 80 hours community service, and as well as paying off some of those fines and court costs. And so our discussion was that those are still true because she violated the time frame in which she was supposed to. And so that's why there was some confusion on this end. But we've discussed that even though she's paid up, or even though she's done some of those community service hours, because they weren't done within the time period that was allotted by the judge, or by the judge's conditions through his probation department, that's still a violation.
Thank you, Mr. Manning. All right. Ms. Simpson, has anyone threatened, forced, or pressured you to plead true to any of these counts?
No.
All right, the court will accept Ms. Simpson's pleas of true to those counts alleged. Mr. Manning, any objections to the state's evidence?
No objection.
All right, the defendant's waiver of rights to plea of true is admitted as evidence. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Any further from the defense?
Nothing from defense, Judge.
All right, then, based on the evidence before the court, Ms. Simpson's pleas of true to the counts alleged, the court will find that Ms. Simpson has violated the terms and conditions of her community supervision. The court will follow the plea agreement reached today between the state and the defense. The court hereby adjudicates Jerica Dion Simpson's guilt for aggravated assault with a deadly weapon, a second-degree felony. The court revokes her community supervision, assesses her punishment at 3 years confinement in the Texas Department of Criminal Justice, orders her to pay the balance of her financial obligations. The court awards her 5 days credit towards her sentence for the time that she has spent in jail on this cause. Ms. Simpson, you hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. Please step over with the deputy to be fingerprinted. Who's next, Mr. Green?
Judge, we have Miss Billy Allen. And that's going to be a motion to withdraw the state's motion to adjudicate. And that was done with the agreement of the Community Supervision Department.
And what's the basis for the withdrawal?
Judge I spoke with her community supervision officer, and they had transferred her to another county. The majority of the issues with compliance that she had was that the other county wasn't accepting her living situation as valid. And so after discussing with our community supervision department, Miss Allen has a job lined up. She has changed her residence to somewhere a little more stable, a little more permanent. And upon speaking with them, they do believe that she has the tools now to be successful that she didn't originally, that were her circumstances were causing her problems, not her attitude or willingness to comply. And that's why the state is willing to reinstate her probation and continue her.
Probation, you verified all of the new living arrangements for Miss Allen. You believe that she's going to be a candidate for successful probation this time?
I have not, but I can check with her officer.
Who did you speak with, Miss Heisel?
Judge, I'm gonna have to look. I don't remember off the top of my head. I've got it right here.
Got some notes.
It's Carolyn, Your Honor, Carolyn Bryant.
I've got some notes on my docket reflecting some amounts. I don't know if these are past due court costs associated with this case or another case. This case. See, so she got on in November of 21 for 2 years. So she's set to expire here in a few months. Does the withdrawal, is there an amendment? Is there an extension? Assuming that she's still way behind on the allegations appear to be failure to pay fine, court costs, attorney fees, supervision fees, your analysis, CSR. Is she going to be able to comply by November 30th of this year?
Judge, while Ms. Burns verifies that, can we call Ms. Allen back up in a little bit?
Sure, that'd be good. I don't know if you heard me, Mr. Manning. I was concerned about her ability to comply with the conditions of community supervision. Prior to her date that she expires, which is November of this year. So if we need to look at redoing the conditions of community supervision, we need to look at extending. Maybe we should do that stuff now rather than waiting 3 or 4 months. Because if she's delinquent on everything, if you're wanting to put her back on, probation's wanting to put her back on, but she's effectively not been on probation and doing the things that she's needed to be doing to be, where she can expire on time. Let's go ahead and look at doing that now rather than later.
Yes, Judge, I'll take us from my communications with her and with the DA's office. I didn't see it as being insurmountable, but I'll double check once we get confirmation with probation.
Thanks. Is Mr. Carroll in the jail? Bryce Carroll. Mr. Manning, I'm ready whenever you are. I was just going to give you some time. No
Yes.
run. You just let me know when you're ready.
I think we can go ahead and go for a minute more, please. Okay, Mr. Briggs.
Braden Lee Briggs, CR 23-7. All right. What are the terms of the plea, Mr. Manning?
Judge, he's been pleading guilty to the evading arrest detention with the vehicle. That plea of guilty is going to result in a agreed punishment of 5 years TCJ, fine of $2,500. Court cost was $290 and reimbursement of $20. He has 165 days credit, and it will run concurrent with any and all other cases that he has.
You said there are 1245s.
No, they're not. This takes care of all his business here in Van Zandt County, but it is concurrent with any other cases he has in other counties.
Okay. All right, Mr. Briggs, sir, can you raise your right hand on the place. So do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah, true.
All right, you can lower your hand. All right, your name is Braden Lee Briggs, is that correct?
Sir.
Mr. Briggs, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
You're represented by your attorney, Mr. Jonathan Manning. Are you pleased with him as your attorney?
Yes, sir.
Do you feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Sir.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
No, sir, there ain't.
Mr. Manning, do you believe Mr. Briggs to be competent?
He is, Judge.
You've explained to him his rights regarding this case. Do you believe he's entering into this plea intentionally, knowingly, and voluntarily?
I do, Judge.
All right, Mr. Briggs, you heard Mr. Manning read the plea agreement. Is that your understanding what the agreement is today?
Yes, sir.
All right, Mr. Briggs, having been indicted with a third-degree felony offense of evading arrest for detention with a vehicle, it does carry a range of punishment, not less than 2 years in prison or more than 10 years in prison, and a fine which cannot exceed $10,000. Court finds that the proposed plea agreement would fit legally within that range of punishment. So, Mr. Briggs, I would ask you at this time, how do you plead to evading arrest or detention with a vehicle?
Guilty.
You're pleading guilty to that crime because you are in fact guilty of committing that crime.
Right.
Has anyone threatened, forced, or pressured you to plead guilty?
No.
All right, court accepts the defendant's plea of guilt. Mr. Manning, any objection to state's evidence?
No objection, states one.
States one is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from state? From the defense?
Rest of closed, Judge.
State, can you give me the evidence?
Yeah, yes, Your Honor. On November 12th of last year, Wills Point PD was working interdiction out on the interstate when they were notified of a stolen vehicle coming through the area. They confirmed through the driver's license plate, that car had been reported stolen. They attempted to make a traffic stop. Initially, the car did slow down, pull over like it was going to stop, but then took off, ended up going down I-20, taking exits, turning around, coming back multiple times. Ultimately, the vehicle was spike strips were deployed in van in front of the Brookshires. The car was disabled and both occupants got out. Mr. Briggs was the driver of that vehicle. And he had warrants out of a different jurisdiction when they confirmed his identity.
Thank you, Ms. Hassel. Anything further, Mr. Manning?
Nothing from defense, Judge.
All right, then based on the evidence presented to the court finds there is enough evidence to convict Mr. Briggs of this offense. Court hereby convicts Braden Lee Briggs of evading arrest or detention with a vehicle, a third-degree felony. Court assesses punishment pursuant to the plea agreement at 5 years confinement in the Texas Department of Criminal Justice. Court orders a $2,500 fine, $290 court cost, $20 reimbursement fees. And the court awards Mr. Briggs 165 days credit towards the sentence for the time that he has spent in jail on this cause. Mr. Briggs, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. Please step over with the deputy to be fingerprinted. All right, Mr. Manning, I'm ready.
Yeah, Judge, this is Mr. Chad Payton.
All right, this is cause number CR 2366, State versus Chad Robert Payton. Mr. Payton, if you'll raise your right hand and place your oath. Sir, do you swear that the testimony you give to the court, the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. You'll lower your hand. Go ahead, Mr. Manning.
Judge, we're proceeding, even though it's an arraignment, we're waive arraignment and are proceeding under a plea. That's going to be for a third-degree offense, possession of controlled substance, penalty group 1 to 4 grams. That was indicted. And upon plea of guilty, the state agrees to recommend punishment be assessed at 7 years, TDCJ, probated for 7 years, and a fine of $2,500, $108 restitution, and state agrees to take DA 2023-0035 under consideration under section 1245 of the Texas Penal Code. In addition to the fine and restitution, there are $209 court cost and $520 reimbursement.
All right, Mr. Payton, you are charged by indictment with a third-degree felony offense, possession of a controlled substance. Penalty group 1, between 1 grams and 4 grams. It does carry a range of punishment of not less than 2 years in prison or more than 10 years in prison, and a fine, if imposed, not more than $10,000. Court finds that the proposed plea agreement fits squarely within the legal range of punishment. Mr. Payton, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
You're represented by Mr. Jonathan Manning. Are you pleased with him as your attorney?
Very pleased, yes, sir.
Have you had enough time to talk to him about your case and then you've had all your legal questions answered?
Yes, sir.
Paperwork that you've read over and signed today, you understand everything that you read and signed.
Yes, sir.
Mr. Manning, do you believe Mr. Payton to be competent?
He is, Judge.
You've explained to him his rights.
I have.
You believe that he's entering into this plea agreement intentionally, knowingly, and voluntarily?
I do, Judge.
All right, Mr. Payton, then how do you plead to possession of a controlled substance, penalty group 1 gram to 4 gram and third-degree felony?
Guilty, sir.
Are you pleading guilty to this crime because you are guilty of committing this crime?
Yes, sir.
Does anyone threaten, force, or pressure you to plead guilty?
Yes, sir.
The court will accept your plea of guilt today. Mr. Manning, any objection to the state's evidence?
No objection to states 1.
States 1 is admitted. The court takes judicial notice of the defendant's judicial confession. Anything further from the state,
No, Your Honor, we'd rest and close.
from the defense?
Nothing from defense, Judge.
Mr. Woodwhite, can you give me the evidence to support the plea?
Yes, Your Honor. On the date in question, which is January 1st of this year, the defendant is pulled over by Wills Point Police Department because the license plate comes on the vehicle he is driving comes back to a different make and model of car. They go back and forth with Mr. Payton, and they get consent to search the vehicle and find in the vehicle in the door pocket an eyeglasses case with a bag of meth inside, and in the frame of the driver door is a headphone case with 2 empty bags and 2 additional bags of meth inside. The lab tests it to 1.10 grams of meth, one of the 3 bags, but we don't believe that the other bags would raise it above the punishment range for this charge.
You said the lab was 1.10.
1.10, one of 3 bags tested.
Okay, thank you. Anything further from the defense?
Nothing from defense, Judge.
All right, then based on the evidence presented to the court finds that there is sufficient evidence to convict Mr. Payton of this offense. Court will follow the plea agreement today. Court hereby convicts Chad Robert Payton of possession of a controlled substance, penalty group 1, between 1 gram and 4 grams, a third-degree felony. Court assesses his sentence at 7 years confinement in the Texas Department of Criminal Justice. Court will suspend that sentence today, place him on 7 years community supervision, order him to pay a $2,500 fine, $180 restitution, $290 court costs, $520 reimbursement fees. The court dismisses under section 1245. DA case number 2023-00035. Mr. Payton, you hereby remanded to the custody of the probation department so they carry out the terms and conditions of the sentence. I'm gonna have you go with the deputy to be fingerprinted on the judgment. After that, the probation officers will give you more information. Anyone else, Mr. Manning?
Yes, Judge, ready on Mr. Eric Hoover.
Eric Hoover, CR 2268. And I have the paperwork on Mr. Hoover, Mr. Manning.
All right, excellent, Judge.
All right, Mr. Hoover, if you'll raise your right hand, and place your oath, sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. You can lower your hand. All right, Mr. Hoover, you are represented by Mr. Manning today. Are you pleased with Mr. Manning as your attorney?
Yes, Your Honor.
Do you feel like you've had enough time to talk with him about the state's motion and amended motion to revoke your community supervision?
Yes, Your Honor.
And you understand everything about the paperwork that you've read over and signed today that's part of your plea agreement?
Yes, sir. Yes, Your Honor.
Mr. Manning, do you believe that Mr. Hoover is competent and if so, that he's entering into this plea intentionally, knowingly, and voluntarily?
I do, Judge.
You've explained to him his rights, is that correct?
I have.
And let me ask this, Mr. Manning, does Mr. Hoover waive the formal reading of the state's amended motion to revoke?
He does, Judge.
Is he pleading true to all 7 counts as alleged?
Judge, he is going to not be pleading true to the count 1, which I believe is the new offenses in Mesquite. As far as I know, that case has not been charged against him yet. And so we would be unable to plead to that.
Is that part of the agreement, see?
Yes, Your Honor, that's correct.
So that's just count 1. What about count 2?
And sorry, yes, and count 2.
That's the state's agreement, Judge. It's counts 1 and 2 the state would be abandoning.
I'm gonna need the judgment corrected again on the judgment revoking community supervision on page 2.
Yes, Judge, we'll get that corrected and sent to Ms. Taberham and Mr. Manning.
All right, Mr. Hoover, you appeared before the court on November 10th, 2022. You pled guilty to the offense of illegal dumping greater than 200 pounds or 200 cubic feet, a state jail felony. Court heard the evidence that day, found that there was enough evidence to convict you. The court followed your plea agreement. The court assessed your punishment at 2 years confinement in state jail of TDC, and then the court suspended that sentence and placed you on 3 years of community supervision. It was during that period that the state filed its amended motion to revoke on April 4th of this year. They have alleged 7 counts, but today the state is abandoning counts 1 and count 2. So what I need to know, Mr. Hoover, is how do you plead to counts 3, 4, 5, 6, and 7? Are those counts true or not true?
They're true, Your Honor.
Mr. Hoover, has anyone threatened you, forced you, pressured you to plead true to any of these counts?
No, Your Honor.
All right, court will accept the defendant's pleas of true. Mr. Manning, any objection to the defendant's waiver of rights, plea of true?
No objection to state 1.
All right, that's admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we would rest and close at this time.
Anything further from the defense?
Hold on, Judge, may I have just a moment?
Yes.
Judge, nothing further from the defense. There's some question about his credit time, as well as whether or not this would run concurrent with any other counties. And what I told him was that this, while it is concurrent, if he does picks up, Dallas County does pick up his charges at some later point in time, those won't be stacked. And so I was explaining that process to him.
What about the credit time? Is that something we need to get cleared up before he gets sent off to TDC? Because if it is incorrect, it may create more work later for all of us.
Judge, the difficulty with the credit time was that he was, when we resolved this original underlying case, he had gotten picked up on some new cases in Van Zandt County that led to this plea, and those were dismissed. So while he was in jail for quite a significant period of time on those new cases in Van Zandt County, he was still on bond for the old case. And so unfortunately, under the statute, he does not get credit for those, even though he was in Van Zandt County serving on cases that were taken into consideration under this previous case.
So is it a question that you and he share? Is it just a question that he shares that you've explained to him legally?
It was a question that he shared that I explained to him.
Okay. All right. So are we ready to proceed?
Yes, Judge.
All right, then court finds it based on the evidence and Mr. Hoover's pleas of true that he has violated the terms and conditions of his community supervision. The court will follow the plea agreement today. Court hereby revokes Court hereby revokes the community supervision of Eric Ashley Hoover. Court assesses his sentence today at 8 months confinement in the Texas Department of Criminal Justice State Jail Division. Court awards him 41 days credit towards that sentence for the time that he has spent in jail on this cause. The court orders him to pay the balance of his financial obligations. Mr. Hoover, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. I'll have you step over with the deputy to be.
Absolutely. Look, Judge, I'm gonna take a break for just a moment, and Mr. Ashworth's gonna take care of his case. Just one case.
Sir.
Okay. Okay. One second.
Mr. Ashworth, you ready?
We're ready, Judge.
Are you ready?
Oh, Mr. Shannon.
How you doing? No, sir.
Hi, this is cause number CR 2182 State versus Alex Chad Manis. Pretrial. Go ahead, Mr. Ashby.
Judge, we've reached an understanding with the state that now that Mr. Manis's mental health care has been restored and rehabilitated, the state is moving to dismiss the case. We're asking the court to sign that order of dismissal. Mr. Manis has had a recent visit to the Andrews Center. As the court knows, he's been undergoing mental health care. He gets a shot once a month at the Andrews Center. He had it Monday. His next appointment ought to be on or about May 25th, 2023. I've explained that to him. I've talked to Jennifer Bashir with the Andrews Center about this week to make sure that Alex had his medicine before he was released, that he has the information for the Andrews Center, a phone number, and I've explained to him that he can call. He needs a ride if he needs some assistance getting over there, that it's on 243, right over in Canton. He does remember where it is. He's been there, and that he can continue ongoing mental health care after his discharge there. So we're asking the court to approve that order and let Alex be released today.
State, that's your motion, right?
It's our motion, Your Honor. This is a state jail charge, and we have held him for 2 years pending his mental health competency restoration process. We don't believe that we can continue to prosecute him further under the Code of Criminal Procedure under those sections.
Okay. All right, Mr. Manis. So what's our plan going forward?
You say you gonna let me go today, sir?
Well, I want to know what's your plan going forward?
I'm gonna get all the medicine and get them that I need. Work a little bit, so.
Okay.
I go to work.
You're not going to be running from the police anymore.
No, sir, I didn't run. I wasn't running in. I was just walking with it. That's okay.
Okay.
I'll you.
But we're not going to have any more run-ins with the police. You're not going to be a
No,
problem.
sir, no, sir, you ain't having a problem with me.
All right. Well, I'm glad that you're doing better. You are looking better.
Well, thank you.
All right. Then the court will grant the state's motion to dismiss. Once the paperwork gets to me, Mr. Manis, I'll sign that and it'll get processed out today. Okay.
All
Today,
right.
buddy.
Yeah, today, get it out.
Hey, Alex, this is that address and phone number.
Okay.
Okay, Judge, can he be excused?
Thank you.
Okay.
All right, thank y'all. Jesus loves you. Read John 15. You just,
Thank you, Mr. Manis.
I think that's from the top. Okay.
There you go. Yeah, 36. That's what it's together. Anyway. Yeah. Thank you. We're just being nice. Can't fault it. Not so much taking order Karen got it. What are you looking for? Tower. Or the
Here, when you picked up the paperwork on the table over here, did you happen to pick up an order of appointment?
Mr. Tyler, what's your last name? Catalog.
I haven't seen any paperwork.
Thanks about it.
Yeah, if you don't mind, it was sitting right there.
Is it a judgment?
No, it's a
Appointment.
first appointment. It's got a little orange sticky note on it.
Well, he's not answering. He's down shop.
Oh, Aaron, hey, oh, shit. I can't, I literally reason. I'll text her. Oh. It's perspective, right. You can go see the statue. Take a picture with Thank you.
Mr. Rainey, you ready?
Yes, Judge. I think we're ready to take Miss Allen back up.
Okay. Ms. Allen, come on back up. CR 21-318. All right, go ahead, Mr. Rainey.
Judge, I was unaware that of the balance. We had. Miss Allen had communicated to me that she was going to be able to get caught up with money that she had on the outside once she was released, but we were unaware of the balance that she had at the district clerk's office. And so upon receiving the balance from both of those, we realized it was probably in her best interest to extend her 6 months so that she would have sufficient amount of time to pay both those balances. And so we have an amendment to probation, which would include the court cost, the updated court cost, and would outline her payment. Additionally, the probation department is waiving the period of the probation fees and the urinalysis fees during the time of extension, so she's not further being added on to during that time.
Okay, are we keeping her expiration period in November of this year?
No, Judge, they're going to extend her to May 29th of 2024.
If you said that, I'm sorry, I didn't hear that. All right, Miss Allen, do me a favor, raise your right hand on the place of oath. Ma'am, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, so Miss Allen, you've heard the conversations that Mr. Manning have been having with the court about your probation case, right?
Yes, sir.
And is this your agreement today? Is this what you're wanting to do, is extend your community supervision, go back on probation?
Yes, sir.
Has anyone threatened or forced you to make you feel like you had to make these agreements today?
No, sir.
All right, the court will grant the state's motion to withdraw the motion to revoke or adjudicate. Court will amend Ms. Allen's community supervision conditions to take into account the waiver of the financial fees, the inclusion of additional fees, and the court will extend her community supervision period for the period stated in the agreement as signed by Ms. Allen. All right, Ms. Allen, once you get out, make sure you report to probation, and hopefully this time around will be a different result than last time.
Yes, sir.
All right. All right, we're your excuse. Who's next, sir?
Judge, we had an add-on, Mr. Candela. Jose Candela.
CR 20-27, State versus Jose Candela. Is this a plea on a third-degree felony theft of property?
Judge, this is a motion to revoke
Okay.
on a theft of a state jail amount.
State jail. All right, give me a second. All right, so what are we doing today, Mr. Reed?
Judge, Mr. Candela is going to plead true to all counts, but count one, which is a new offense out of Dallas County. And in exchange for that plea, he is going to be sentenced to 7 months confinement in a state jail with balanced financial obligations. And that is restitution in the amount of $4,186.39, as well as court cost of $47.01. He has credit time in the amount of 7 months.
Yeah, 7 months exactly.
Yes, Judge. Well, I'm sorry, he may have more than 7 months, but they only gave him the 7 months as that was our agreement.
All right, any other 1245s or other cases being resolved?
Nothing from this county judge.
All right, Mr. Candela, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you can bow your hand. All right, Mr. Candela, you're represented in this case by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney?
Yes, sir.
You feel like you've had enough time to talk with him about your case, and that you've had all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
No, sir.
Mr. Manning, do you believe Mr. Candela to be competent today? And if so, have you explained to him his rights as they pertain to this case? And is he entering into this agreement intentionally, knowingly, and voluntarily?
Judge, he is competent. He is entering into this agreement potentially knowing and voluntarily. He's participated in providing mitigation on this case, and he's ready to proceed on this revocation.
All right, Mr. Candela, you appeared before the court on April 29th, 2021. You pled guilty to the state jail felony offense of theft of property, $2,500 to $30,000. Court heard the evidence that day, found that there was enough evidence to convict you. The court followed your plea agreement that you reached with the state. The court assessed your punishment at 2 years confinement in the state jail division of TDC. Court later suspended that sentence and placed you on probation for a period of 2 years. It was during that period of probation that the state filed its motion to revoke your community supervision in March 5th, I believe, of this year. And in that motion, they have alleged what appears to be 6 separate counts of violations. The court finds that the state, correct me if I'm wrong, state, you're abandoning count 1 and proceeding on counts 2 through 6. Is that correct, state?
That's correct, Your Honor.
All right, Mr. Candela, understanding the plea agreement, I would ask you at this time, how do you plead to counts 2, 3, 4, 5, and 6?
Guilty. True.
All right, you're pleading true to each one of those counts because each one of the counts, what's being alleged is in fact true.
Yes.
Has anyone threatened you, forced you, pressured you to plead true to any of these counts?
No.
All right, court will accept the defendant's plea of true. Mr. Manning, any objection to the admission of the defendant's waiver of rights plea of true?
No objection.
All right, that evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Judge, just that there is, once again, I've corrected the judgment and set it to Ms. Taberham and Mr. Manning to remove count 1 and I guess it's condition A from the judgment. Beyond that, we have nothing further at this time.
Thank you, Mr. White. Anything further, Mr. Manning?
Judge, I would just note, while the restitution amount seems a bit large, Mr. Candela has actually paid, I believe, close to half of the restitution that was originally ordered. And he was doing fairly well until he had several incidents happen, including a car wreck. And so he's getting back on his feet, and he anticipates being able to pay off the rest of that restitution once he is released from jail.
Mr. Manning, I'm sure you counseled your client. He understands that just because he's pleading today does not relieve him of the obligation to pay restitution, fines, or court costs.
I have, Judge, and as you can see, he only has $47 remaining on the court cost. And like I said, that restitution was double that amount when he first went on probation.
All right, Mr. Candela, then the court finds that you have violated the terms and conditions of your community supervision. court, following your plea agreement today, revokes your community supervision, assesses your punishment at 7 months confinement, State Jail Division of TDC. Court orders you to pay the balance of your financial obligations. The court will give you credit for time served for your entire sentence for the time that you have already spent in jail on this cause. You're hereby remanded to the custody of the Payne County Sheriff so he can carry out the terms and conditions of the sentence. Please step over with a deputy to be fingerprinted.
Thank you.
Go ahead, Mr. Payne.
Yes, Judge, just was appointed today, Mr. Tyler Tadlock.
All right, Tyler, Jason Tadlock, CR 2376. All right, the court has found Mr. Tadlock to be indigent for purposes of the Sixth Amendment. The court has appointed the Honorable Jonathan Manning to represent Mr. Tadlock. Have you had an opportunity to go over the indictment sponsor?
Yes, Judge, we've gone over the indictments in CR 2376. And his name is spelled correctly. He understands the charge against him. He is pleading not guilty to that charge and request to be set on the pretrial docket. Our request for pretrial would be asked to be set out a little bit further because of the number of charges and because of it seems that they are different dates. And so if we can just have a little bit longer pretrial, so I can get with the DA's office and see what cases we're going forward on.
All right, court will find that Mr. Tadlock has waived the formal requirements of arraignment or will enter his plea of not guilty into the record. Court sets this matter for pretrial hearing June 15th.
Judge,
All right, court sets Mr. Tadlock for pretrial hearing June 15th. Mr. Tadlock, if you make bail, you're out of jail, your hearings will be at 9 a.m. in the morning at the courthouse. If you do not make bail and you remain in jail, then your hearings will always be at 1:30.
That's what it is.
I know you've got Don and Michelle's name,
Judge, we still got 3 more before Mr. Boylan.
Leonard Williams and Randy Young. Who's next?
Judge, let's go ahead and start with Mr. Williams.
All right, this is cause number CR 2372, State versus Leonard Marshall Williams.
Judge, this was one that I had spoken to Mr. Williams on. We're going to file a motion to suppress. I did not get that timely filed. I spoke to the state at the beginning of this week. I have been in contact with them regarding specific items of discovery that were missing that I think would be dispositive on this case. And so I'm working those paths parallel, but we would like to continue at this point, still going forward with an evidentiary motion. Like I said, that was my fault for not getting timely filed. But we would request to be set again on the evidentiary docket, provided the discovery request do not solve that issue before our next hearing.
But you do have your motion filed, it was just not timely filed.
No, Judge, I have not filed it. I spoke to Mr. Woodward at the beginning this week. He brought some additional information to my attention that I haven't yet talked to my client. But we will, based on my conversation with my client today, we will be going forward on a motion to suppress. It just has not been filed yet.
All right.
Judge, for the court's information as well, I would remind the court that Mr. Manning is not the first attorney on this. There was a previous motion to suppress filed. I believe we filed a response to it. State would have no objection to resetting, allow Mr. Manning to file that motion. We have been in contact. I've been in contact with the arresting agency trying to get some more information that the defense has requested. We're in the process of doing that as well. So if we could have some time, state would not be opposed to resetting for another contested docket, see if we can't get all that information and a good game plan of how we're going to move forward.
All right, court will set Mr. Williams for 2 settings. I'm gonna set it for evidentiary hearing on May 30th. And I'm gonna go ahead and set it for docket call on May 30th. That way, if there is no motion, then I'll expect to hear some kind of announcement on that day.
Yes, Judge.
All right, who do you want next?
Judge, if we can do Mr. Randy Young.
Randy Leonard Young, CR 22-349. Mr. Young is set for pretrial.
Yes, Judge. At this time, we don't have any contested pre-trial. I would request to be set on docket call. However, I am in negotiations with Ms. Heisel. The co-defendant in this case has been taken into federal custody, and so I believe that with his federal custody, there will be a disposition that will be coming in our case as well.
All right, court will set Mr. Young for docket call. Do you want that June 1st date, Mr. Manning?
Yes, Judge.
All right, June 1st at 1:30.
And then Judge, Mr. Donnell Shelton.
All right, Mr. Shelton, CR 22-47, CR 22-48 for docket call. Go, Mr. Manning.
Judge, this is a case that I was subbed in on for Mr. Ashmore. And I have yet had the opportunity to sit down and go over with Mr. Shelton, the evidence against him on this case, as well as any potential defenses. My understanding is that he is specially set in October 30th. And we would like, after my conversations with him, we would like to keep that special setting. But I would like us to have some additional time for me to review the case, make sure I have an understanding of the facts, the issues at hand, as well as possibly reach out and present some possible defenses to the state as well.
Okay, so the announcement in effect is there's no agreement and he wants his trial, as specially said, already by the court on October 30th.
Well, Judge, I haven't received a plea offer on Mr. Shelton's case, so I don't know if there's something to convey. I believe that he received an offer previously, and I believe that this is Ms. Curry's case as well.
All right, court will set Mr. Shelton for jury trial as well. The court's already set him, so I think I just placed him back on for your benefit, Mr. Manning. So if you have all the discovery, then I'll just allow you to do what you do between now and jury trial.
Judge, may I ask if we do reach, and I'm not saying we're at that point, but if we do reach an agreement, are you saying that the court will not accept it past this point? Or will you allow us, if we reach an agreement before that special setting, will you allow us to present that to the court?
The court's policy is not to accept a plea agreement after docket call. However, the court will entertain a plea agreement, but I'm not telling you I would accept it. I'm not telling you. No, I'm
Just-
not accept it. I'm just telling you.
I'm sorry, Judge, you cut out there at the end.
It's okay. I quit talking because you were going to say something. I'm saying the court's policy is I do not accept plea agreements after docket call. Mr. Shelton's been on docket call for multiple times. So I don't believe that he's going to reach an agreement. So I'm not really inclined to take a plea agreement. So, but I'm saying if you and the state think that there's a compelling reason that the court should entertain a plea agreement, the court's never declined parties from bringing it to the court's attention. The court has rejected some, the court has accepted some, as is the court's discretion.
Okay, Judge, and the restate for that was just the 10:30 date, is that correct?
Yes, I'm just saying, I'm going to carry him on jury selection for his special setting on October 30th. If anything happens between now and then, you'll let me know. Otherwise, he's not going to be on the docket.
Yes, Judge. Judge, I believe that concludes my docket except for Mr. Boylan.
Okay. Is Mr. Balboa in the courtroom?
Judge, Mr. Balboa has retained Mr. Nolan White, and that motion to substitute was filed this week.
Yeah, I'm aware. If he's in the courtroom, I was going to bring him up. Make sure that he's aware of that and then reset his case because we're set today.
Your Honor, I did not bring him up. I'm reaching out to your coordinator. I was under the understanding that Mr. White had filed a motion for continuance, and I just got a text from her. Anyway,
No, that's okay. Let's just do a resetting. And I have not had a chance to go. The motion was just filed late yesterday, so I didn't have a chance to entertain it in time for today. So let's just reset Mr. Balboa for. Let's do Thursday, May 11th. We'll just set that. He's got a new case, CR 22-369. That's for arraignment, May 11th. And the other one says absconded.
Except for status, Your Honor.
I think it was. We'll just set it for pretrial. Give him a chance to run those two cases together. All right, so that just leaves us with Mr. Boylan.
and Mr. Carroll, we do have Mr. Carroll in the room, Your Honor.
Oh, yeah, it's Mr. Bryce Carroll.
Yes, sir.
Mr. Carroll, come on up, sir. All right, Mr. Carroll, what's our plan attorney wise? Are you going to hire an attorney? Are you requesting a court-appointed lawyer? What's your plan?
Court appointed.
Court-appointed. Have you filled out the paperwork and sent it over yet?
Sorry.
All right, I can't appoint you an attorney until you do that. So after this hearing, you need to go get that paperwork completed, filled out, leave it with the staff. They'll send it over and we'll be able to review it for you, okay? All right, I'm going to reset you to May 9th to give you time to do that. And if you'll get that paperwork sent over, if I find that you're indigent, I can appoint an attorney that can talk with you before May 9th, okay?
Do I need an attorney?
Why don't you just fill out the paperwork. Fill out the paperwork first, and then we'll cross that other bridge later.
Hey, Maria. How are
Hey,
you?
Mr. Boyle, I'm good. How are you, sir?
All right.
All right, Mr. Manning, are you and Mr. Boylan ready?
Hey, Miss Martin,
How
I
you
got
doing?
some bad news to tell you, my friend. And this happened today, sir.
Hang on, you said you got what to tell me?
I got some real bad news to tell you, my friend. And
Oh,
this
no.
happened twice.
Well, let's hear about it.
It was two emergencies, and I told all four of these officers. And I want this officer, where you can see him in his face, where I'm gonna tell you his name. And he's here right now, and he's a jailer. He was one of them that was the first one here this morning.
Well, tell me what happened.
Yeah. The first time I had a real bad chest pain this morning, Mr. Martin, was at 6:37 a.m. this morning. And I called control. And this officer, his name was Jonathan Davidson. And he told me just like this, and I can bring all 150 inmates up here as witnesses. They all heard this. Because I even asked for Mama Erin this one. That's how upset I was. Because Mama Erin knows what I'm about to say. The nurse, and you know who I'm talking about, man, Miss Kim. She asked me that on the 10th, that magazine, Sergeant Davidson told Jonathan Davidson to throw it in the trash, and I was right there in detox. This was on March of this year, last month. I was in the detox tank. I had an accident in 12 cell, and Sergeant Davidson put both of his hands on me. They didn't even have a camera this morning. And this is why I've been so upset. I had to literally call my mama. This was 3 months. Today it makes 3 months exactly. From when I called my mom. And I had to tell my mama to call up here. And they still call my mama a liar.
Okay, what else? Tell me about the other things.
And this is 2 times today. This was the second time. And this is when Mr. Manning come and check. I told him I needed to go to the hospital. And I literally told him what my blood pressure was.
Judge, what he's trying to say is, I went back to see if Mr. Boyle was gonna be coming to court today. And he expressed to me that he felt like he was having a medical emergency, and that his blood pressure was highly elevated. I asked him if he'd been checked out by medical staff, and
I said no.
and so at this point, he says that has not been checked out.
Not once. I called this morning, Mr. Martin, and as soon as he came, I told him about the first one, and this was the second time. It started at 13:08, and God literally helped me. And I'm telling you the truth. I got the Bible in my pocket. That's why I'm saying this, Miss Martin. God literally helped me. By my right side, my fist, and I'm going to show you, Mr. Martin, so you can see. My fists were literally like this together, and my arms were really shaking really hard. And all 150 inmates is here heard me the first time, and this is exactly what he said. The night that this Mexican dude that killed himself in cell 10. And I'm speaking up for this man because the sergeant that was in charge that night was Sergeant Lockhead. Mills was here that night. Bowling was here that night. And yeah, you were Mills. No, I'm just saying. These were the 5 people here that night when he hung himself. It was Sergeant Lockhead, Mills, Jonathan Davis, Bowling, and Miss Reeves. And the only one got fired for that was Miss Reeves when it was on Sergeant Lockhead's head. He was in charge. He left 3 minutes after Sergeant Miss Reeves called the suicide, and he left at 2023, Judge Martin. And this ain't no lie. And he radioed back right at 2400, which was midnight. And yes, this man is actually talking to me right now. He's telling me to let you know that the four that should be fired was Mills, Sergeant Lucky, Jonathan Davis, and Bowling, because Miss Reed responded that quick. Because I screamed for her, because he said the same thing that night about to that man, and I heard it. Like he told me this morning. And he said it just like this, and I ain't lying, Mr. Martin. He said, you could fucking die. That's what he told me. His exact words on the intercom, and everybody heard it.
Okay, well, I appreciate you telling me, and I'll talk with Sheriff Carter about that, okay?
Because
Judge, so we're set today here for status on the competency restoration. My information is that as of I believe last week, Mr. Borland has moved up from 128 to 73 on that list for Terrell State for a bed for competency restoration.
I talked to my doctor, and I brought the address to his seat. This is the one I'm talking about.
Once we get there, we don't, Judge, I'll talk to you about it, okay?
No, I've been saying, so you can, because I've been there and I've already talked to him. I sent him an email, he's done it today. And he said I could come and I could even live there because that's the whole address of it. And he said I wouldn't even have to go to the police department.
Okay, we gotta get Judge.
That's why I let him know.
All right, so what I'm gonna do, Mr. Boylan, is I'm gonna reset your case again so that I can meet with you. It sounds like we're making some pretty good progress on getting you to Terrell State Hospital, like what we need to do, because that's what the court order says. So I'm gonna reset you for another status so I can check on you. We're gonna set this in.
We're going there. She's in there.
Mr. Manning, what does your July look like?
Judge, if you give me just a moment.
Sir, I got
I'll have a
settings on the 6th and the 13th. I don't know if you got a vacation letter in that day or not.
Judge, I have a vacation letter for the week of the 3rd through the 7th.
What about July 13th?
July 13th works great, Judge.
All right, let's put Mr. Boylan on Thursday, July 13th. And in the meantime, Mr. Manning and I will talk with Sheriff Carter and I'll check into those things, Mr. Boylan, okay?
Now I also got something else to tell you, Mr. Martin. I've even called and I've asked for so which is me. I don't know if he done it. This is the day that this happened. That Monday when I talk that Saturday I'm talking about, I called my mom. I called Richard Smitty that Monday, and I told Richard Smitty, I said, Richard Smitty, could you please call Mr. Martin and let him know and then be taken to the mental hospital? Because I've literally been through all this on my own, no help, and I'm fixing to tell you what it is. I've had it real bad, and that sound like this. And my mom told me to let you know everything, so you know. From the time I was 12 weeks to 3 months old, this is why I'm like this. And my mom told me to let you already know, the only thing I'm gonna pass on is the probation question, and that's it. Because I was on 15 years probation for this. And I'm not lying, you already know which one I'm talking about, the case. And I got several witnesses that know me that is here right now. I can call all 4 of them up here. And I went to school with all 4 of these girls. and they're all 4 here. I know them by first and last name. And they already done told me about it, and I want them to back me up. They said, yes, they would. And I've got their initials as well as my middle school sweetheart. We were together all 4 years. And the stuff that's on the internet is not true at all, sir.
Okay.
And the girl I'm fixing to give you.
Judge,
is her
Judge,
first
I'd
and
ask
last
at
name.
this point, we go ahead and reset Mr. Borland, and I'll speak to him about some additional information he has.
All right, thank you, Mr. Manning. All right, Mr. Boylan, I'm gonna come back and we'll see you on July 13th, and I'll get with Mr. Manning and I'll get with Sheriff Carter about the things you told me today, okay? And I appreciate you telling me those things.
And just so you know, Mr. Martin.
He's reset your case.
I know, I'm just gonna, this is what I'm asking to do, so I don't have to stay here anymore. I'm asking for a court order, and I'm asking, this is reaching my Mr. Martin. And I know you'll do this real quick. I've been dealing with PSCG since I was 11 years old, and I don't know how to deal with it. That's how long I've been dealing with it.
Okay, well, when we get you to Terrell State Hospital, and I think we're getting pretty close to that, they're gonna be able to help you with your PTSD and anything else that you're dealing with. So we're working on that. Okay, we're
Yep.
working on that. You just be patient.
But see, Mr. Martin, this is what I'm trying to tell you. When I asked these people to call the crisis center for me, so I could talk with my caseworker. One of my crisis caseworkers at Terrell State Hospital at the Andrew Center in Tyler, Texas. My doctor, Dr. Corey Corbett, his son is my new psychiatrist. He told me if I need any problem to call him.
Okay.
And I sent him a message, sir.
Okay.
Saying what I'm dealing with.
All right, I'll talk to the jail staff about that and we'll see if there's any way we can get you to see a therapist if that's what you're wanting to do.
And I literally asked the nurse, I gave her,
I understand. I understand what you're telling me. So you've told me. So now let me talk with them and we'll see what we can do. Okay.
thank you.
All right. Thank you, Mr. Boylan. Thank you, Mr. Manning.
For your status and your evaluation.
Your Honor, is there anything else we can do for you out here at the jail today?
We told Mr. Balboa, right? We told him that we've reset him and he's not coming up, right?
I will let him know. I haven't done that yet, but I will let him know.
Okay, good. Yeah, we reset him May, I think, what did I say, May 11th?
Judge, you said May 11th. Miss Salzman with Mr. White's office told me that he probably has a doctor's appointment May 11th. But I think we can just trust Mr. White to inform the court of what a better date would be, and we'll move it in advance of that and get it taken care of. But
Did she give you?
she just sent me an email. She's watching the stream, I'm assuming.
Oh. Well, we can set May 9th. I just need to know.
I think we'll just, I'll send Mr. White a message that it's been set for the 11th. If he needs to move it forward or back because of that, obviously we'll have no problem with that and we'll just get it taken care of. I just don't know his schedule, but
Okay.
she told me he does have an appointment the 11th. So just so the court's aware, we'll move that, but he can confer that with Mr. Balboa and we'll move forward on that when the time comes.
Okay, will do. I appreciate that.
So we're sticking with May 11th.
Let's stick with May 11th. We'll let Mr. White decide what the better date is. He can contact the court. We'll figure that out.
Yes, Judge.
All right, I think that's all that I have.
Thank you, sir.
Appreciate y'all's help today.